Good morning, everybody. This is my name's Don Anderson. I'm the chair of the Planning Matters Subcommittee. I'm going to have the meetings being recorded by LCAT, as you guys obviously can see, but we're also going to be taping it. So let me see if I have this thing not screwed up to get this going. Of course I am. Had the thing running before. Maybe it was on a dead battery. Who knows? Anyway, we'll
Is
try
it
to-
working?
Anyway,
I-
you ever use one of these, George?
Yeah.
Okay,
Okay,
thank you.
George.
George is
He's a
helping.
techie guy. Oh, stay tuned.
All right.
Do you want me to record on my phone?
No, this is from the town clerk's office.
Okay.
But thank you, Jane.
Thank you, though. I appreciate that. All right, I'll speak slow until George gets it going. I think we have a sign-in sheet. Everyone is signed in over here. All right. We do have a quorum of the committee members, and what we're going to do today is our focus is going to be discussing the mixed-use zoning district and amendment to the zoning map. This is a matter presented to us by the East Long Meadow Planning Board, and we're just going to try to hit some of the high points and so forth. This is going to be a relatively informal format, but at the end, we want to try to get at least some of the concerns and points of focus from the committee. We do have people, from the petitioner is the town of East Long Meadow, but we have members from, is it no longer M&A? It's now, we're calling you East Long Meadow redevelopers. We have
East Long Meadow redevelopers is
Okay.
the
All right, we
development.
have John and Joe from there, as well as their counsel, Jane. And we also have a resident, Marlene Goldstein, as well as George Kingston from the Planning Board. Okay, I'll toss it out. I know a lot of people have been looking at the draft bylaw. Thoughts about mixed use in general, mixture, okay? The initial draft that was given by the planning board speaks of not less than 5%, nor greater than 15%. What are your thoughts on that, committee? Is that too low? Is that about right?
No, my position would be that's too low.
Okay,
If we're looking at a mixed-use development, and we're going to do 85% residential and 15% commercial, I think that's an imbalance.
I know I had a talk with one of the petitioner's attorneys, and I mentioned that we have Ralph just joined us. I'll pass over the sign-in sheet. Ralph, just to bring you up to speed, you didn't really miss anything. We're talking about mixed use and how we, as individual members of the committee, see that.
Okay.
The petition by the planning board talks a range of 5 to 15%. And Tom is just mentioning that number to him seems on the low side. And I'll go back to Tom now that Ralph's up to speed.
No, I guess that's pretty much what I have to say is that if we're going to be looking at a mixed use, let's make it a true mixed use if we decide to move in that direction. But 85-15 at best is not mixed use to me.
No.
It's not a split.
Sid?
I'd like to find out, the planning board came up with this. I'd like to hear George's reasoning for coming up between 5 and 15 before I say anything.
That's a fair point. George, you prepared to answer that?
Yeah, we looked at it, initially said 5 to 10, and we bumped it up to 15. We're looking at the mixed-use buildings themselves will probably be 3 stories. Okay, so if your your non-residential is on the first floor, and that's 25% right there. But the developers have also been talking about having townhouses and standalone houses that on the development, which would bring that number down from 25. And we also spoke with the proponents, and they had concerns about being able to guarantee that they could fill up more than that 5% minimum. Okay, that initially it may be an issue to to meet higher than that number. So we felt it was a compromise. We didn't want it to be all commercial, which is why we put 15 at the top. We were bouncing between 10 and 20, and we said 15. Okay, and the 5 is just an absolute minimum.
Okay.
It'll depend on market conditions.
I mean, my comments to that when I was talking to Attorney Fitzgerald is, I personally have a problem with the 5%, and I told him, I said, it reminds me more of a hotel, where you have a beautiful hotel, and then you have the sundry stores, the Starbucks and so forth in there. So as opposed to being a mixed use, it seems to be almost a living quarters with, ancillary type things as opposed to mixed use. Mixed use to me is also a higher percentage, but your thoughts, Sid?
Well, my thought is, again, what you mentioned about a concern. I'd hate to see empty storefronts because that might discourage people from moving there. However, I do feel 5% is too small. I always take the Center Square project, and I think if you took this project and put it actually on a site that we're looking at, how would that look aesthetically, and how would that provide not just for that section, but for the entire town? Again, what if we do go through a recession? Again, we do have empty buildings in town. My thought is a minimum of at least 10 to 13% would be a nice compromise. As far as looking at the maximum, that's up for everybody to discuss.
Any other, Ralph, you have any comments?
I do. 5% I think is definitely too small. I think a mixed-use development has to be for the benefit of the entire town and not just the surrounding buildings and residentials right in that little niche mixed-use district. With that being said, more commercial, a 10 or 15%, maybe even higher than that, would end up being a benefit for the whole town and not just the residents around it.
Again, my thought is also you do have to look at a minimum for any development in East Long Meadow because of the economic conditions too. So I agree, it should be more than 5%, but it also, you want to have storefronts that have thriving businesses too. So that's something, I do think it should be more than 5%. I don't think we should get into numbers where, if you don't do 25%, we don't want you here. I think you got to look at it with a common sense approach.
Okay. Marilyn?
Through the chair, there was a lot of, now, and for disclosure, Ralph and I looked at this together during the summer when we were waiting for things to get moving, and we put down some thoughts, and recognizing that this is a bylaw for the town, not for any specific development. I do recognize when you have an applicant staring you in the face that is influential to some of the numbers and some of the things that you come up with. I have been a support person for mixed use from the get-go, long before we were even sitting at this table when I was still on the planning board. And my experience and research with the successful mixed use developments, they're located between highways, they're more urban situated, there's public transportation, there's rail. None of that applies here in East Long Meadow. And I was at the planning board meeting when East Long Meadow redevelopers presented their real estate team's findings of having researched the area for what they want to do for their parcel. And the numbers weren't great. And so you're hearing now that, and John Takano used to use, we'd like to be on the corner of Main and Main, and then you use the example of Elm and Elm, and now the real estate numbers didn't even fit for that recommendation. So I asked the hard question, so perhaps this is not a good fit for East Long Meadow. And I was met with a very energized response. Oh, absolutely, we just have to work harder. The town doesn't need a large residential development. That I think is understood. I heard that even from the planning board. And so here we are, trying to come up with a town bylaw for the entire town, and we know there are other vacant properties available. And are these properties any more suited to this use than the other property that's been discussed? And I can't answer that. I think this process is a bylaw. It's a land use opportunity. How it plays out, the town puts down on paper what we feel is in the best interest of East Long Meadow. And how it plays out depends on who chooses to act on that bylaw. We have a number of multifamily bylaws already existing in our bylaws, and they don't fit for this particular use. I understand that. The point is, we can't make decisions based on what we think might happen in the future, what we think might happen in terms of the ability to succeed. If the fit works for East Long Meadow at whatever level, as we see it here, then it's up to the future developers to decide if it's in their best interest to move forward. But we have to come back to what East Long Meadow needs.
Absolutely. And with this, I'll ask you, George, did the planning board look at other mixed-use bylaws in the state? I think
Yes.
Okay. That helped in you determining this. My thought also, depending on if you said at Coughlin's, if you said at coffee time, you'll hear what everybody wants. From what I've seen, I've heard people saying, this is going to be a village concept. If it's a village concept, great. If it's going to be one apartment building reaching up into the sky, I don't think the town wants that. I don't think it would benefit East Long Meadow. A village concept would benefit East Long Meadow, where, look, we're growing. We're no longer a town, we're a city. We're going to have to look at expansion at some point, just like our infrastructure. So this is just one thing that we should look at. And again, Marilyn, you're right. This is not about one project. This is about the future of East Long Meadow. We've got to look at what's best for the entire area, not just one project.
And if I may,
Please.
adding to that, when there was discussion this summer between Ralph and myself in terms of the non-residential piece versus the residential component. It's clear we don't want a dominated residential project. So what's in the best interest of fitting the description or the definition of what a mixed use is? We've seen a proposal out for Eastfield Mall, which is interesting, and it's kind of like a 60-40. So we looked at a minimum of 20% and a maximum of 30%, which would give a little bit more emphasis to the non-residential piece, because clearly the less commercial piece you have, the more residential, the more impact on town services and potentially schools. Not that we're against children, but the point is we have to look at a balance in our town.
Okay. Question.
Yes.
And with that, that means there will be storefronts built, minimum of 20%. They may not necessarily be filled, but they will be there for occupation.
I'm not a developer. I would think that a developer would carve out some applicants and some contracts before they even put the first shovel in the ground. I mean, that to me would be the thing to do. I don't want for the town to create a bylaw that is going to set someone up to fail, but we're talking about mixed use.
Right.
And at George's, at the planning board meeting last Tuesday, the Pioneer Valley Planning Commission attended, and I was there. And after the meeting, I discussed a certain situation with one of the representatives and mentioned we had a proposal for mixed use. And she was pleased to hear that until she heard it was a minimum of 5%. And she said, that's not mixed use. So that just verifies what we've all been feeling all along.
Historically, I'll chime in just a little bit. Historically, my experience is for a last mixed-use project that I recall during my planning board days was one on Maple Street where they were going to have almost like, I don't want to use the word strip mall, but a strip mall type buildings, and then have above them would be apartments. And that didn't move forward because the the developer refused to have the requisite number of parking. Wanted to maximize the project, and the project just didn't go forward because we couldn't get past the really tough parking, and then the parking would have rolled over onto other public facility parking spots over on Maple Court, et cetera, et cetera. The other bit, so that my vision of a multi-use, mixed use, would be, as I'm looking out the window, would be like Center Square, saying we want to add 2 layers of, assuming they have the parking, 2 layers of apartments or above that. Could be, that's my image of it, and that's perhaps because of what my first instance of it was that proposed project over on Maple Street. I think I'm kind of tending to agree to 20 to 30%, but I also think it should be a kind of a moving scale, and I have to remind everybody, including myself, that we are not voting on a project. We're voting on a bylaw that, if passed, could apply to other parts of East Long Meadow. As much as I wish our golf courses and golf course facilities the best of luck as they move forward, we don't know if what we're viewing today and as that moves forward may be applied to Elmcrest, maybe not. May be applied to Fenway Golf, maybe not. But, I think the percentage should be on the north end of it when the project is being built in an industrial or business zone. If it's being built somewhere else, perhaps it can be a little less, depending, again, if it's in the heart of a residential area. But this is what this meeting's for, is to get a feel for the committee members, subcommittee members, and what the feeling is. But I think, if I have to look at this particular project, we're right across from American Saw, as whatever it's, the current name, I still call it that. We're in the middle of that area, and to have 5%, it seems to be kind of a very stark contrast to its location. Whereas a 5%, which I'm not in favor of, again, I'm not in favor of it, may not seem as shocking if they put this project in, say, Fenway Golf, okay? That, again, I'm saying this just for effect. I'm not saying that I'm supporting the 5%, but I believe a mixed use, to me, is a higher, especially if we're building one in an industrial zone or a business zone like this, that it's somewhat in parity, so it transitions naturally to what's surrounding you as well.
So the subcommittee is pretty much in agreement. The minimum should be more than 5%.
Yeah, that's what I'm gathering from this. Am I misspeak? Okay. All right. So.
Could I add just 2 points?
Sure, George.
You keep talking about retail. The percentage includes both retail and business. Okay.
So it could be an insurance company or someone like that.
Could be an office.
Yeah.
Could be WeWork sort of thing.
Right.
Okay. So you got to remember, it won't all be retail. There will be
Understood.
other things there. The other thing is to keep in mind, as you point out, this is a general bylaw to cover the whole town. Any project that goes in under this bylaw will be under special permit, which allows you then to tailor the project to whether it's in the IGP or whether it's in Fenway or whether it's in a farm somewhere in town.
Mm-hmm.
So just to keep that in mind going forward.
Absolutely.
Okay, thank you. I'll go back to George on this one again. When you guys had your discussion on the 5% as a minimum, was that pretty much, what were some of the pros and cons that you guys used to reach that conclusion?
Well, none of us, except for Tide, are really developers, so we don't have the appreciation for the economics of something like this or the market for something like this right now.
Okay.
We have to rely on the proponents to tell us about market conditions and what they think works. So we did. We asked them what a bare minimum would be, because we didn't want to be 100% residential. But we also understand that market conditions change, and that depending on what the market conditions are when this project or any other project starts. Those percentages may be somewhere in that range, okay? Sorry about my throat, allergies. But in any case, that was how we came up with a broader range than simply making it too narrow.
Okay, very good. All right, unless there's any other committee comments, I'm going to move over to my next bullet point, if you will. I'm trying to understand in general description, it's also mentioned also under definition, and we see it a couple other spots. It talks about multi-use dwellings with or without business or commercial spaces. Just so we're clear, I'm going to go ask George, what was the intent of that with or without? Does that give the planning board the opportunity to not have commercial spaces, or?
No.
I just want to be sure we're clear.
It's a development consisting of a mixture of residential, commercial, and business uses.
Okay,
Okay, so the mixture is there. The building types can include single-family dwellings, townhouses, and multifamily dwellings with or without business or commercial spaces. That would allow for multifamily buildings other than the ones that have the commercial space in them. Okay?
okay,
So, but all of that would go into the total square footage that you would then be doing your 5, 10, 20%, 30%, whatever it happens to be.
okay.
Okay? So, yeah, again, we're trying not to be overly restrictive in a generally worded bylaw like this, as opposed to looking at a specific project where you're issuing a special permit that would allow the specific types of housing that are in the project.
Very good, thank you. Any comments on that from any of the committee members? Marilyn?
Through the chair, that was something that we struggled with when Ralph and I talked about it, because initially it didn't make sense, and then we figured it out.
Okay.
And so, maybe we can just massage the language a little bit if this moves forward, so that people don't have to struggle and figure it out. The other piece that's in that definition, which I have since come full circle on, was the issue of recreation. It just mentions recreation, and as the general description starts, you're talking about business and commercial uses, building types, single-family dwelling, townhouses, multifamily dwelling, with or without business or commercial spaces. Business and commercial buildings, recreation and open space. Did that recreation mean passive recreation? Did that recreation mean a recreational facility, a recreational use? And so at one point I just added facility after recreation, thinking that would fit. And I'm thinking it's more in line with just passive recreation, the open
trails.
space. Right, because it's next to open space, so I was looking to just clarify that with passive recreation. That would be a piece, that's all.
So you're suggesting recreation, either passive or facility?
That could happen.
Yeah, okay.
So,
But there has to be a recreational component. Okay.
am I reflecting what we chatted about?
Absolutely.
Okay.
All right.
John, I have a
Please.
question. Right now, we allow a home office for a business. I would assume, obviously, the bylaw would still allow that. If you're running a home office business out of your house, how is that going to reflect on the percentage of business?
It shouldn't count. It shouldn't count one.
It should still stay
it's
as a
yeah,
residential portion.
right. Because that would be under the control of an individual tenant or property owner, and not under the project itself. So the project itself, it shouldn't mitigate those numbers one bit, in my opinion.
And I was just trying to scan through grid. Marilyn, you may remember there was a specific wording, work at home or...
In the table of uses, it's a work study.
Live workspace.
Let's see. Live workspace, thank you, right. Which is not defined, so we weren't sure what that meant. And we didn't know if that was part and parcel to what we already do with our home office. So that's something
Yeah.
we just need to chat about.
Yeah, I mean, my opinion is if you have something outside of the control of the project where it's at the whim of whoever the owner is of that individual unit, it shouldn't count toward the percentages, but that's just me.
I think when we talked about the lived workspace, we were talking about an area that is officially a office area, such as, say, a medical professional's office, dentist, let's say,
Right.
for an example, attached to a living space for that individual or that family. So it would be, that's what we understood to be a live workspace. Okay, the old concept when I was growing up in the Bronx where the dentist had his office on the first floor and he lived above it, you know,
Yeah.
that sort of thing.
Okay.
I guess definition's in order, that's all.
Yeah,
That's
definitions
exactly.
are always
Right,
difficult,
right,
as you know.
right.
I'm going to go to section 2 purpose, 2.13. One of the comments is, it says provide additional housing. And this is something that I had a conversation with Attorney Fitzgerald. And during the summer, I think we've all done a lot of research and prepping for this meeting and future meetings. And I know in Boston, for instance, if they have a project over a certain size, and this would certainly more than qualify, they require 13% affordable housing. Underscore the word, it's affordable housing. I didn't say low income, it says affordable, and affordable is defined by the community.
No.
It's, in other words, affordable in Boston. What I'm trying to say is affordable in Boston is not the same as affordable
affordable
in
for East Long
Springfield
Meadow.
or Worcester,
Right.
correct?
You need to understand that affordable is a code word for subsidized.
Okay. May I?
Please.
All right. I was at the planning board meeting Tuesday night, and Pioneer Valley was there to give a presentation on affordable housing. And I guess the planning board didn't feel that this was an issue on the table. And then the director mentioned that this was coming up in discussion with a mixed-use development. So there was a little bit of information that was shared. And there is I have the information that currently East Long Meadow, then this is based on the 2017 numbers. Now, originally the numbers we talked about were from the 2010 census. And the numbers are actually a little bit less. The 2010 census indicated that we met 10%, or we were at 10%, which is the requirement for our regional fair share. Now, it was close to 10%. Now we are at, it says 7%. We have 6,154 housing units. We have subsidized housing inventory at 445. And the regional fair share for East Long Meadow, there is an additional 170 affordable units. Now, that's always been out there. We are a diverse community, and with that come diverse housing needs. And we do have subsidized housing in town through our elderly housing projects. And that's what the bulk of our subsidized housing. We do have one comprehensive permit on Benton Drive. So, that being said, that has always been something that's there. And when you're talking about creating a development that will enhance the housing stock with upper, higher end units, and that's what we're hearing, that you can't legislate that in a bylaw, but that's what we're hearing, that will not address this particular need. And actually, it won't address another need that the town has, and that was presented pretty well at your meeting, George, from the director of the Council on Aging, Carolyn Brennan, who indicated that the seniors, a lot of the folks that live in East Long Meadow, they don't meet the low to moderate income, and they don't meet the luxury standard, and they're sort of caught in the middle. And they're looking for units that are in the $1,200 to $1,500 range, monthly rent with 2 bedrooms, laundry, and I think she said carports, I'm not sure. But anyway, the point is that this bylaw, the way it's written, to me doesn't address either of those issues. And I don't know that we can, through land use, address either of those issues. But there was some discussion in a previous plan before us about a host community agreement. And I pulled out the one from Hopkinton that the attorney gave us at our last discussion regarding this. Is there some way within that agreement that the town can, with a project like this, advocate for either a certain percentage of what you brought up with low to moderate, which is considered subsidized, but our numbers are different than Springfield's and other communities it's based on, I believe, our median income for East Long Meadow. And so those numbers are, I believe, created that way. Or can we even, through the community host document, require a certain percentage being market rate, which is, right now, it's between the 1,200 to 1,500 rate that Carolyn expressed at the meeting. It would be nice. It would be nice to have a project, a proposal, a bylaw that addresses a mixed use with a good complement of balance between the uses, and perhaps address a need that East Long Meadow clearly has.
No, I agree, and I think what's important also is the fact, I think we need to, maybe through the Pioneer Valley Planning Commission or maybe somehow reach out to how Boston does it, because Boston does require, as far as I know, 13% on projects of a certain size has to be in compliance. So in other words, you could have one project like this, which is, concierge living and so forth and so on, and then those numbers can be worked against us in the future, saying, well, listen, Town of East Long Meadow, it was very clear it was concierge living. It's very clear that it's a higher price point, and it's very clear that these are not counting toward your affordable housing numbers. And so I want to find out what Boston has done, and not necessarily mirror exactly what they've done, but obviously their bylaws and laws have passed the muster. They're not, of allowing, I said 13%. Now, in some of my conversations, I know from talking to the petitioner's attorney, not petitioner, the developer's attorney, that there is some latitude there where you don't, I don't want to put words, through, words in your mouth, but that there's a sensitivity to not knowingly come out and eviscerate the town's numbers down to whatever number it would be if this project became totally concierge living. That's correct, right? I'm just,
Throwing it out there.
throwing it out there, Jane, that's all I'm doing over there. So your thoughts, my thoughts are, that it's an important matter to the town of East Long Meadow, because if this puts us in a point where we're extremely vulnerable to another comprehensive permit, I think we need to have some, whether it's, we should have some type of protections that are like other sister communities in the Commonwealth have done to protect the town from that happening. And I couldn't support. We have a project. In the developer's perfect world, it would add about 10% of the voting population of East Long Meadow in full occupancy, and that one project alone could really negatively impact our numbers vis-a-vis our 7%. So I think we need to. That's to me is extremely important, and we need something that we can put together. And as long as I understand the developer is not adverse to it, that we can put something together to help protect the numbers we have and certainly not make it any worse.
Through the chair,
Please.
we got to come back full circle. This is a town bylaw. We're not dealing with a project before us. I know it's out there, and I understand.
I know.
But we have to look at what would fit, and also
But I
Future,
have to,
future planning boards. We
we do,
won't
and I
have George
agree.
forever.
well, hopefully we will, and you as well, and everyone here. No, but my point is, it's what we used to say in law school, the but-for test.
Yeah.
But for the developer, the planning board not likely would be submitting this petition before us.
I agree.
So as much as I would like to ignore the person behind the curtain, I really cannot do that. I have to be mindful of that, because if this were presented by Center Square project, it perhaps would have a different look to it than this. So, so I just have to be aware of what's, that the developer is very much the impetus that led to the planning board, that led to this subcommittee meeting. So I can't discount that. And I do want, and I do have to remind myself, and all of us as well, that this, again, we're not voting on the project, we're voting on a bylaw. But there is you can certainly see the direction of this bylaw is a different bylaw, in my humble opinion, than the one we would have seen if this were another petitioner, a developer coming in as well. So, I mean, it does flavor it. George?
Just one additional comment here. I understand the need for affordable housing, okay? Before we get too hung up on the numbers, though, I would like to point out that of 40 some odd towns and cities in the Pioneer Valley Planning Commission's area, only 4 meet the 10%. Okay, Chicopee, Springfield, Holyoke, and one other, okay, maybe Ludlow. All the others, quite a few of them are lower than us in terms of that. So, and there is no explicit penalty for not meeting your numbers. The only thing it does is put you in a less favorable position if someone does come in with a comprehensive permit.
Correct.
Okay. And when you think about that, you need to think about what land prices are in East Long Meadow right now as to what the threat's going to be. Just as something to think about.
So, through the chair, it sounds like numbers would be in order, but my thought is to allow those to be negotiated through a host community agreement instead of trying to muddy the bylaw down. I'm trying to look at this as make the bylaw favorable or something that a developer would want, and then allow the town manager or whoever we need to negotiate all the other talking points. Any impact to the town, affordable housing, something like that. But I did notice in the bylaw, under the special permit, there is no mention of host community agreement. And I think that would be something that would have to be mandated within the bylaw, that a host community agreement must be obtained. And here's the criteria that has to go into a host community agreement.
Good point. Now, question, again, this is not on the project, it's in general. Do we want defined distinctions between percent of condominiums versus apartments, or let the market dictate that? Or is that something I think there's some talk of certain percentages, apartment or condominiums. Any thought by the committee on that?
I would like to see that explored as well. I think that's an important piece of any mixed-use district.
Mm-hmm.
I don't want to see high-rise apartment buildings going in solely to meet the needs of that mixed use, but I also like to see townhouses and condominiums be built as well as part of that to round that development out.
Okay.
I have a comment. I'm just trying to find the location. Because I questioned with, we all know what a single family,
I'm in section 3.
3.11 single family dwellings and then
Yeah.
townhouses, right. And I noticed that in the 3.12 townhouses is under 5.322 in our bylaw. And I believe that's under planned adult residential. And they give a definition. Let me just find it, please. Okay. Planned unit residential is 5.32. Okay, townhouses. It's a single-family dwelling connected by one or more common walls. However, there shall be no more than 6 and no less than 2 townhouses per structure. So that definition alone drives, and they reference it in the bylaw.
Excuse me, could you read that again?
Yes, okay. Townhouses, a single-family dwelling connected by one or more common walls. However, there shall be no more than 6 and no less than 2 townhouses per structure. So,
Thank you.
you're welcome. That
Sure.
defines what a townhouse is. That could also be a condominium, depending on if it's ownership. I think is it fair to say, and I'm not really savvy with that condominium drives ownership. Townhouse could
No, you
effectively
could,
be a rental, but
no, townhouses are quite
But also-
common condominiums.
condominiums.
Yeah,
So
Excuse me,
that's-
do they
I'm
they
sorry.
don't need to be condominiums.
They don't need to be. That's what I wanted to find out was the intent of the planning board to have it basically up to the individual developer, whether they want to do a percentage of condominiums versus apartments, or is it really just a function of whatever the developer feels is appropriate for that site?
Well, I defer to the developer, but as I understand, it, what we're talking about is the ownership class, if you will. You can own a townhouse or a single-family house. You can own it as a condominium, which means that you're owning it jointly with the other people that live there. Or you can rent it, which means that you don't own it. You're just leasing it from the owner.
Mm-hmm.
Okay, so those are forms of ownership. They don't define whether it's a structure or not. An apartment building can be a condo, okay, and not a rental, and often they are, okay. So we felt that was something that ownership structure is something that the market would dictate, okay, whether or not people, how long, part of it is how long are people going to be there. Okay, rental tends to be shorter term than condominium owning, okay, because you're paying by the month and you can move out whenever you want, basically, depending on your lease. So that's the kind of market-driven percentages that will be dependent on the individual project, okay. It might be different, for instance, at the Elms than it would be here or someplace else in town. So to put that in the bylaw is kind of, it's not really land use. There you're dictating ownership
Yeah.
structure.
Well, this is kind of where this move led to another move. Now I'm going to go right over, and again, I'm not reserved, I'm going to go back again. That tie-in goes to Section 9, Community Association 9.1A. Now, if a condo has a condominium association, that's just required as by Chapter 183, it's just a given. However, this community association that will maintain this, and that, is that going to be, if it's an apartment, then the owner is a member of this association, not the renter.
Right.
So my point is, it's trying to get a feel for this consistent with the other part. In other words, a community association, it seems that, that utilities, land, facilities, accessing, blah, 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 are all going to be maintained by this association. And if we have projects that are 100% apartments or 20% condominiums and so forth, then we're going to have one particular owner that's going to ostensibly control the association. I just want to make sure that's okay.
Yeah.
Okay, just want to be clear on that one, because, that kind of gave me the feeling that it's a condominium-esque type feeling, whereas a renter probably doesn't, their rent will chip in, but the real controller would be whoever the landlord is, would be the member of the association. Is that the understanding?
The purpose of the association, as with any association like that, is to make sure that someone is responsible for the project. If it's all condos, and the developer has sold everything, he's not there anymore, who's going to be responsible for maintaining the common structures? Okay, that's why you have an association, that's why you have a homeowners association and a development, so that the common infrastructure associated with that development that's not owned by the town is maintained, okay, and that the rules of the subdivision are enforced. And this would be the same thing. If the developer goes totally rental, then there's no problem because you have an owner there who's responsible. But if the owner sells off the units as condominiums, as individual properties, then you need the association, so there's someone responsible for taking care of it all. That's why that's there.
No, I just wanted to be, because it seemed to be really pushing that the condominium portion would probably be higher, because let's say 70% of is rentals, hypothetically. And if they're rentals, and they're owned by the developer, and wants to, keep it as a future annuity income source, that developer will obviously have a weighted interest in funding and keeping this project together, whereas the 25% who are condo owners would be forever a minority interest in making decisions of association expenses and so forth and so on. So that leads me to the next point. Do we want a percentage of either so that it's balanced, or does it, again, not this project as we move forward in general, or does it let the market dictate that?
What do you think?
Balance is the key piece, and I have some notes here with looking for definitions to understand what kind of structures we're talking about, and I thought that perhaps bless you that there would be an allocation. In fact, in conversation with the chairman of the planning board, he was under the impression that the bylaw had that in it, that there was so much for the townhouse, a certain percentage townhouse, certain percentage apartment, and it's not there. So, but am interested to see something there. I don't want to see an entire apartment complex. So, I'm looking at a mixed use of residential uses, a mixed use of commercial uses. In the best world, I would personally like to see some sort of guideline regarding those numbers.
Yeah.
And also, we have two definitions in our bylaw for multifamily, and I'm assuming that apartments would fall under multifamily. And so that needs to be clarified. What does multifamily mean with respect to a mixed-use development? One of the definitions for multifamily comes under planned unit residential district, which is our current, that was our first multifamily development before the town. It's a 40-acre minimum parcel, and it highlights either single-family townhouses, multifamily. In this definition is multifamily dwellings, including garden units, not exceeding 6 units per building. I can't believe that that's a definition that mixed use would want to have, but it's here. 6 units per building of multifamily. I mean, I don't know what kind, I'm not sure. I think that would be somewhat restrictive for this type of use. The bylaw under Section 8 has, under dwelling multifamily, a building containing at least 2 dwelling units with separate cooking, sleeping, and sanitary facilities. That's it. That's more general, and I think that this bylaw that comes from planned unit residential is too restrictive, I think, for this type. So we should clarify that as well.
Okay, fair point.
Through the chair?
Yes.
Just a minor point, community association.
Mm-hmm.
Something that stuck out with me is that we're listing association responsibilities for permanent maintenance, and we're listing a number of items, communal water, sewage, common open space, recreational, and there's thoroughfare facilities. I'm assuming that means roads?
I
And
I
sidewalks?
circled that too. This
And
is language
driveways?
from someplace else.
Yeah, so I would like to see that better defined, because
Yeah.
I'm not comfortable with thoroughfare facilities. I think that needs to be very clear. If we're clearly stating what the other ones are, let's say roads, sidewalks, driveways. Let's say what we mean.
Absolutely, fair point. The other comment is it very clear what percentage of ownership, of influence of the community association would an owner of, say, let's say Starbucks wants to open in there? Will they have a say on that? Will they be able to own their building, their unit? You have places like Dunkin' Donuts that in their perfect world they'd like to own. Or they say, no, I don't want to rent, I want to buy. Is that precluded in there? And if so, let's say a developer, nothing here, specifically, but a developer now sold a project, it's all owned by the condos or whoever the property owners who are renting. What happens with the businesses? Are the businesses also voting members? Are they not voting members? I don't know. I mean, who's paying that? They're certainly drawing a lot of business into that project. They certainly, if I were a condo owner, I'd say, how come they're not part of this association and helping are they paying for all the morning traffic coming in grabbing coffee here and things of that nature? So I think we have to kind of sort that out, is because what this presupposes is that the developer or its successor will always be there as the property manager, but can a mixed use also have owned business buildings, almost like a business condo? I wasn't getting, like I said, I'm not picking that up one way or the other. Maybe that's another point we should be looking into.
Is that within the purview of zoning?
I'm just thinking about
I
here
mean,
with the
because
association.
yeah.
Yeah, I think it is, because if we're asking an association, I think we're looking at the association through eyes of the residential owners.
Okay.
But if we have, say, 20% of this project are other places, other dentist office, other kind of places where outside people are coming in, and they're bringing in traffic, they're bringing in their, Coca-Cola deliveries and things of that nature, what is their responsibility in the association to maintain this? Is it a matter of just getting common area surcharges every once in a while to say that? I mean, is that something? And the other part is, from a planning point of view, is there something here where, it's allowed uses of owned units, commercial units being owned by the developer? By the business owner. I want to open up an insurance company in there, but I want to own that,
There's nothing in here that precludes that.
Well, that's what I want to make sure,
Right.
and if I do own it, now am I part of this community association as a business owner?
Well, here's the point. Again, this is a general bylaw, okay?
Right.
Community associations have their own charters and bylaws
Right.
and structure.
But we're
And-
dictating it and having the town attorney review it.
Yeah.
So we kind of got ourselves married into it to some degree.
Yeah, but my point is that a lot of the questions you're asking are things that would be in the charter and bylaws of the association. And that might differ from one project to another, depending on the structure of the project. The reason we want to have the town attorney review those documents is to make sure that the town is protected. That's what it's really all about. Because in a project as proposed, and as we're trying to write this generally for, the infrastructure of the project is owned by whoever owns the project. the town does not accept the roads and the water and everything else when we do with the subdivision. Those would remain under the ownership of whoever owns partially or totally the project. So the town needs to be protected so that if the sewers fail, okay, and we gotta go in there and fix them because it's a health issue, we're covered. We can charge them for whatever it is they have to
Well,
do.
and that's that's what I'm trying to figure out too, is since this is a mixed use, can it be, does the owners of the businesses also, are they part of the association? I think it should be in there. I don't think it should be up in the air, because I think it should be, I think we need to define who the members are gonna be.
What
Ralph?
you're actually looking for is a development association instead of the community being residential association. Meaning,
right.
who's ever within this development is a member of the association, and you're all partially responsible to take care of the
Right,
roads.
the percentages can
septics,
be
and everything.
worked out amongst themselves. I just want to make sure that this community association seems to suggest it's the residential community. And I want to make sure it's also the businesses, because, on there, so,
I would agree with that through the chair.
Yeah.
thank you.
May I? To the
Please.
chair? Okay. While George was talking, I was thumbing through the bylaw, trying to look at planned business development, and which is our center square. That's
Mhm.
planned business development, and the bylaw is totally silent on any kind of association. My assumption is the property's owned and they lease, but perhaps there's individual ownership within the development that has been silent as far as what the town is concerned. We did have a mitigation agreement with this development for concerns with traffic. And, but other than that, there was no real issue with that. But I'm listening to what you're saying. I just didn't know what we did with planned business development.
I don't. And which it leads me to, again, another one of these hypotheticals, I'm just throwing it out there, I don't expect answers, is if this passes, is there anticipated that other existing planned business, planned residential will convert or have the option to convert to this type? For instance, let's say Center Square Grill wants to do that. Let's say Elmcrest wants to do that. Elmcrest says, we want to add a Starbucks into our facility. We want to do this and turn existing. Is this, again, I'm just, the curse of having me on your chair, I ask these crazy questions. Yeah,
It would simply be a zone change. They would have to go to the council petition, and they would have to start the whole process.
right.
Like we're doing right now.
Yeah.
Yeah.
They may not have the patience.
Good point.
Exactly, but that's still a possibility, though. Somebody could come in and say, listen, we want to offer this and that, and, 5% or whatever number of percent. I have a few other, I think we already kind of intentionally covered that. Height restrictions, thoughts on that? Their proposal says, at least the last one I saw was 50 feet and maximum. We comfortable with that number, or is that too high, just about right? Thoughts,
Through the chair?
please?
I'm not comfortable with that.
Okay.
I've been very clear in the past that I don't want to see anything higher than 40 feet, but a lot of it depends on the setback
Okay.
and how that building is presented to the roadside.
Mhm.
If we want to do a 4-foot or 4-story structure in the back of the property and do a 3 in the front, that's great. If we want to do all 4s without any kind of setback or any kind of buffer, I would not be in agreement with that.
Because one of the taller buildings in town is Bluebird Estates, but that's not as, you can't, that's in a swale or ravine, the lower area. So the height is kind of a misnomer, because you're looking at the street, you really can't see this structure because you have to go down into it. So, so I think that's what you're saying is the visual impact it would have on the on there as well.
Yeah, through the chair, I've done a lot of traveling down south, and they have some great developments down there, very similar to this project, with mixed use. And you can't even see I'll call it the mall area, because of the use of the buffers. They have arborvitaes and berms and things of that nature, which blend in with the aesthetics of the land, which make it look great.
Okay.
Yeah, and all of a sudden, you see a driveway saying, Tom's Condo's this way. And then you go through there, and it's a road with a bunch of shops,
Mhm.
which is great.
Really?
Through the chair, when the town was dealing with Bluebird Estates, at that time, our height requirement was, I believe, 35 feet maximum. And there was a massaging of the bylaw, if you will, under special permit for an additional 10 feet. If the topography or if the conditions of the development supported it and made it,
Mhm.
conducive to what was around. And in this bylaw, I thought that with 35 feet being the maximum structure, I mean, we're talking anywhere in town. We're not talking about
Right.
legacy sites,
Yeah.
industrial property. We're talking anywhere in town. And yes, there's a part of this bylaw that addresses developing in concert with what your surrounding area is of that development, and I was happy to see that. But I don't want to, I would like to see some differential between height requirements and a project like this to offer different textures, different looks. And so if perhaps, like the original bylaw that we spent so much time on, there was a different height requirement, 400 feet off the property,
Mhm.
the front line, and I would certainly be interested in that type of modification. And so maybe 35 feet streetwise at street length, and then as you go out 400 feet, then it could be 45.
Yeah, and that includes.
I mean,
the roads.
that's my
Right.
opinion. I'm just looking for visual
Yeah.
in terms of what.
Or, or 40 feet, like you were saying, 45, yeah.
Well, 45 is a standard in our town
Okay.
with Bluebird.
All right.
That's a standard that's been established. And
Yeah, I
so,
know. It's just, like I said, it's because of its location. For Bluebird, we're at street level. I don't know
Right.
if they would have gotten the 45 back in the day, but that's
Well,
just
this
me.
project
Well-
would be under special permit too, which gives
Yeah.
the planning board
And
the
design
ability to make
review,
that.
too.
Right.
Site plan review and design review.
And design review.
So,
Right.
and that was what it came down to when our discussions is you really need to look at the heights on a project-by-project basis and where they lie in the project, which is a matter of site plan review and design review rather than being cast in stone in the bylaw, because you don't want to have to go back to modify the bylaw every time something new comes in, okay, quite frankly. We chose the 50 feet after discussions with the proponent, and it was explained to us the need for certain story heights, particularly the first floor. You think of 10 feet, but it's more than that, because with current utilities and everything else, you really need a utility space above the first floor if it's going to be retail or offices before you can get into your residential. So the 50 feet was seen as a working floor and 3 residential floors. Okay, and that was where the number came from. And it came from largely from the advice of the proponents of the particular project, because when they explained to us how buildings are built today versus how they were built 50 years ago or 100 years ago, it's very different in terms of what you need for infrastructure inside the building itself. Venting and air conditioning and everything else that has to go into the ceiling.
So the question is, hypothetically, if we went with the 50 feet, can that be specific to buildings that have commercial business uses necessitating that additional 10 feet for utility? In other words, if somebody wants to put in they get their percentages here, okay? So let's say it's 20%. They get their percentage here and they want to do a standalone residential. this seems to suggest, unless I'm reading it wrong, they can go all the way up to 50 feet regardless of whether there's a commercial or business.
Right.
Maybe have that, or, 40 feet or what have you, or 50 if necessitated by a commercial first floor or business use. Thoughts? Because that seemed to be the condition, why you want the why they wanted the 50 is because of that. So if there's a standalone residential only, then they don't need the 50, correct?
Yeah.
Okay. All right. Let me see how we're doing time-wise. I promised you guys not a long meeting. I'm at the 1 hour, a little over an hour point. So, is this time a good time for you guys? If I move forward on, I'm looking at, I watched your eyes.
Time, but I will work my calendar.
If I keep the
whatever
meeting
I
around
can.
hour-ish or something like that?
I'll find a way.
Okay, all right. You guys are all in my email string, so I'm gonna try to again check. I don't wanna set a meeting at this point, but I think, what I'll do is I'll have a more, now that I've had your comments on here, I'm gonna have a little more defined focus so we can come up with more definitive numbers. As, right now, today was just more open discussion and thoughts and so forth.
What is the timeline for having this completed?
I would,
Quickly
as quickly as possible. I'd like to see if we can get some thoughts, assuming there's no revisions to this one, with, hopefully get either at a vote or close to a vote at the next
Can we
meeting.
set a tentative meeting now since we're all together?
Yeah,
Oh, absolutely.
I'm fine with that.
We still have to look at the table of uses too. But,
And there's one other elephant in the room, and that is the lot size.
Oh, yeah,
It was
fair point.
40 acres,
Right.
and now it's down to 20 acres.
well, there was,
Good point, Tom. Please.
there was some discussion with that between Ralph and myself. And, you vacillate back and forth. I know the issue with 20 acres, or at least I think, if I understand this correctly, George, when your planning board talked about it, the issue of the 20 acres was to sort of hone in the project a little bit, so that perhaps the 20 acres would be more doable, more, the chance of success would be better than if it was on a 40-acre parcel, and much larger concept. At least that's what I thought I took from that discussion. However, there was some discussion between Ralph and myself regarding the 40 acres versus 20 acres. And jump in, Ralph, if I'm not presenting what we talked about. But the feeling was we're looking at creating a district, and that the concern would be, a number of these developments occurring throughout the community. Not that we're trying to squelch growth. The problem is the demand for service, and there's no age restriction, and so we'd be advocating for 20-acre developments with apartments in a number of places in town. Because these apartments could be different with different proponents. So we looked at 40 acres for a district requirement with a mixed-use development within that 40 acres at 20. So that you zone the whole property is 40 acres, but you can do as little as 20 acres of development within that property for starters. That was what I felt we were.
That's what we had talked about.
Right.
40, what do I want to say, continuous acres, so that they couldn't say, I own 20 acres here and 20 acres here. But to do a district that is a minimum size of 40
Right.
acres and a development of 20 acres, which would also give developers the chance to divide the property, do a development, see how it's working, see how it's going, before they choose whether or not they want to start another development on another portion. Or they could do a 40-acre development all at the same time.
Right.
They may decide on this one to do 70% apartments, but on this one do more townhouses or something. that's what I had batted around. I wasn't sure. If you think of it as a whole, this room being 40 acres, this is the district. The development is only 20 acres, half of it to start.
And in addition,
Not sure how legal that is, commanding a district to be a minimum size.
well, I would expect that any development would be done in phases anyway. That's my experience with subdivisions, doing things in phases. But if you have, like a planned business development, you have the entire plan in front of you, you know what's proposed for that parcel. And that would be the same thing with the 20-acre minimum development within the district. You would know what's proposed for that parcel. It may not all happen overnight. They may choose to
Phase it.
Phase it in. And I would think realistically that would be the case. So those were our thoughts.
Yeah, I mean, there's pros and cons to the smaller, and I think I might be, as I'm thinking, is the smaller size, a higher percentage of commercial business use. Like, for instance, I don't know what the acres, and because we're sitting here, I'm using Center Square Grill. Say Center Square Grill says, listen, we got the parking, hypothetically, or Center Square Grill, Center Square project, and says, we want to now add apartments above the entire top. Well, that's not 20 acres, is it?
I don't know. I don't know.
So, I never looked. So my point is that do we want to create a bylaw for mixed use that if somebody wants to have a mixed use in, on Shaker Road or someone over here, that they can't because they don't have 40 acres or 20 acres?
Visually, the Fields of Chestnut is 25.
Okay.
Well, it was a minimum of 25, and I want to say that I think they were close to that. The Elms are 40.
Okay.
So visually, you can get a handle on the scope of the project size.
So if Center Square wanted to do a mixed use under the 20 acres, they wouldn't be able to. They don't have enough property.
Okay, and from a planning, bylaw point of view, is that something we want in a mixed use, or do we want to allow something smaller with a higher percentage in there so that we can create a center living area
Right.
in East Long Meadow? I kind of think I'd like that.
George, if I may,
Yeah.
I believe I was at a planning board meeting of which development within the center, apartments above buildings and all was brought up. And I believe that was like a separate, not district wording, that county had. for it.
That's correct.
Okay. The concept of mixed use, there's lots of different concepts, okay? This bylaw is designed for the village separate development type of mixed use, where you have a parcel and you're going to create a village on the parcel, okay? There's been significant discussion about how would you do that, how would you convert the center to something more like a Boston area where you've got stores and houses and housing above them. And we felt that this bylaw couldn't cover both of those options. That if you're going to go into an existing developed area and try to add additional housing by taking down the old buildings and putting up new ones that look nice, that have that, you have different issues on parking, you have different density issues. It's apples and oranges. You can't squeeze them into one section of the bylaw. And since there isn't any proposals to do anything like that right now, we felt that that it would be inappropriate to try to deal with both things at the same time.
Sure.
So we came up with this bylaw specifically for the village-oriented thing. We did discuss the 20 versus 40 acres a lot. And I think it was Tide who finally said, look, we ought to make it 20 acres because it increases the number of sites in town where this could happen and is less restrictive. You don't want to be so restrictive that there's only one parcel in town that this applies to, okay? Because that's sort of spot zoning. It's not really, but it sort of is. And so we compromised on the 20. I don't think the board was opposed to 40, but we, in the end, felt that it was more reasonable to make it 20. And that's how we got there.
Then I think for clarity, we should probably change the district to say mixed-use village zoning district. Because if I represented a company trying to come in East Long Meadow and to put in I would say, well, this is our mixed-use zoning district. So I would say that we should make it specific to that, and that opens up for a future conversation of having a mixed-use district for the center of town, either as an overlay or something as well, just for thoughts. Maybe that could be part of the master plan conversation too. Marilyn?
Just a comment, and I really don't have a good handle on our industrial garden park, whether it be that or Deer Park. What's out there, what in terms of the different sites. My only concern about a 20-acre parcel is if there were other opportunities for vacant buildings within our industrial garden park to be designated for a future village use. This is a zone that has its benefits to our community. We're looking at potentially 40 acres already to be pulled out of that use, never to be back there again. And so the smaller the parcel, is there a risk that we could see other buildings that are left in disrepair to rot and then,
Well, I think if we have it
And then-
called a village, we now open up the opportunity to have a larger piece, maybe 35, 40 acres, something of that nature, because it's a mixed-use village. And because I was, smaller, if we're trying to do mixed-use zoning for everything, then smaller might be better to be more inclusive. But if we're doing a village, I think make the village a little larger area-wise. That way you can have more recreational and so forth in there.
Through the chair.
Please.
You also have to trust your boards to do the zone change also.
Right.
That could be a no vote. Second, it's been in the back of my mind when we're looking at this, not that it would be financially feasible for more green space, but some possible future mixed-use developments may be looking at putting parking garages out. That would actually give you more green space, and it would be attached to maybe some of the buildings for convenience.
Where there could be less area, an offset for having more walking trails and green space and things of that nature, making it more of a village. Yeah, I think my thoughts, again, if we keep it more, if we understand, I have a better clarity on this as a village than I would as mixed use, because I keep thinking of other mixed uses, and I would like the planning board, again, I'm speaking for myself, not for the council, to look at mixed use for other parts of East Long Meadow, more specific, like around this neck where people can walk and grab a coffee and go out and and do other things and be able to be part of a center community. So, what other bullet points am I missing now? Did we cover them all? I mean, the highlight ones. All right. So what I'm going to do is I'm going to look at my calendar and see what we have for meetings available. Monday seem good to you guys?
Sure.
All right. Give us a chance.
2 weeks.
In 2 weeks? All right. That would be the 23rd. Same, 10, talking to Don Mackey, 10:30 still fine with your class?
Yep. Thank you.
Okay. Whenever next meeting, the 23rd of September at 10:30, right here, assuming it's available?
I know, yes, through the chair, I know I asked how long do we want to take on this? Should we set a time frame for actually finishing this
I'm really
up?
hoping next one is going to be more, this was just a general, get a vibe for the council, the subcommittee. What are your thoughts, Ralph?
We're gonna be able to finish it.
No,
next
no.
No. I think next one, we're going to have more structure. I think we're going to
We'll
start
have more
hitting.
structure with it.
Right.
Table of use, we'll hit that.
Yep,
And possibly by the third or the fourth meeting, we should.
exactly, yeah, I think we do that, maybe we could have meetings a little more closer together. So now we have 2 weeks to look at the table of use and to really think about what we just talked about today.
Point of
George?
order. You're our expert on the charter, Ralph.
I have the charter with.
What does it say about when the town council has to take action on a petition?
45 days after their public hearing. So they have to hold the
Okay.
public hearing, and then they have 45 days to take action on it.
But they have to hold the public hearing within a certain period of time after it's submitted, don't they?
No.
No.
No? Okay, fine.
We were concerned about that,
Okay.
and we looked into that, so.
All right, so
Will we
the,
hopefully have the minutes before
I
to
am
review?
going.
See, that's the issue.
If I have 2 seconds, I'm gonna go see Diane over in the assessors. Apparently, they took over. We have a program here in East Long Meadow. We afford seniors the chance to work off their tax burden by giving to the town. So I thought the town clerk's office had that, but apparently that's been transferred over to the assessor's office. So as soon as I'm done, we're done here, I'm walking over there to see if I can look at who they have as candidates, to take a look at Don's video when it goes up, and to do,
Listen to that.
and listen to this as well, and to be able to put something together. But I think the video will be a little clearer because here we have to kind of distinguish which voice is what, whereas the video will I think will be a little cleaner on that. But this does afford us redundancy. God forbid there was an issue with the video.
Okay.
Okay. All right. 9:23, 10:30, right here. I'm going to entertain a motion to adjourn.
Public?
Motion is made,
Public?
seconded.
No?
I'm sorry.
No public?
Not on this one. This one, I was telling Jane, I just said, I will let you make a comment, John. Go ahead.
Sorry.
It wasn't on it, but like I said, this is, go ahead, please do. You guys came up here.
No, I just want to know how we could be of assistance to you in your deliberations. When we worked with the planning board, there were things that the planning board asked for, where they said, can you show us, for example, how a mixed-use building is put together? And that's how the height was arrived at, those
Okay.
types of things. So is there information coming out of today that you think would be helpful to the committee that you'd like to see? Would you like to see any of our thoughts on your comments?
Well, I mean, if you want to do it through council, have Jane put together a memo of your comments over to us. And what I could do for the 23rd meeting, if we can limit it to no more than a half hour, is to have, your thoughts? What do you think?
Well,
Again, I keep getting reminded by the subcommittee, that the petitioner is the planning board.
Right, right.
And I find myself sometimes getting brought back in to you. I would just say that if you relay some of the concerns through council and gets it over, I will share it with the subcommittee, and we will have that as talking points for the next meeting.
And I have a quick question.
Yes, Sid.
Through the chair. Anything talked about today, does that sound outrageous?
Outrageous? No.
Okay. Doable for any town in Massachusetts?
I could tick them off and I could answer them in
No, I'm just.
30 seconds.
Overall, I know we're not going to be a complete agreement, but we're looking for the future of the town. I know you're looking for probability of the project. So we have this decision here.
Well, we're also members of the town too.
Yes.
We're not buying to sell it, we're here to hold it.
Right, that's great.
So we're interested in what the outcome is.
Okay, good.
Okay, we have a motion on the floor made and seconded. And again, just remind you, while we're in discussion on it, our next meeting is the 23rd at 10:30, hopefully in this room. I'll ask our town clerk's office to make sure they hold the space, and I'll call for a vote. All in favor?
Aye.
Aye. All opposed? Motion carries. Thank you, everybody.